Hello everybody, and welcome to History Bite number 50, dated September 22nd, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled The Alleged Illegality of the 14th Amendment. As the name suggests, there is a very small group of right-wing so-called legal scholars and historians who feel that the 14th Amendment to the U.S. Constitution is somehow invalid or illegally adopted, okay, and thus having no effect on the country. Their arguments come from the realities of how the amendment came into being. Now, we know very well that the 14th Amendment is a mighty, mighty knight in shining armor in the Constitution, protecting individual rights and liberties as well as due process of law against arbitrary state infringement. So it's no wonder why this very select group of right-wingers, who nobody really pays attention to anyway, feels that the 14th Amendment is somehow not a valid part of the Constitution. So allow me to explain the roots of where their opposition to the amendment comes from. First and foremost, they feel that because the southern states, those that were previously part of the treasonous and rebellious Confederate States of America, were not represented in Congress, that the mere passage of the amendment was unlawful because you had several states not even represented. Okay? Whatever. And number two, they feel that given that the southern states who were part of the Confederacy, all except Tennessee, were virtually forced to ratify the amendment at gunpoint, you know, so melodramatic due to military occupation, that the amendment was not ratified in the normal democratic process, that they were forced to ratify it if they wanted to rejoin the Union, and that's not the way it's supposed to be, and yada yada. Okay, fine. So these are their 2 points of opposition, and they feel that because of these two things, the way the 14th Amendment was crafted and ultimately ratified was invalid, and thus the whole thing, just throw the whole thing out in the trash. Okay? So allow me to respond to those points of opposition. First and foremost, with respect to the passage of the 14th Amendment. At the time the 14th Amendment was passed, in June of 1866, all of those states of the former Confederacy were still technically out of the Union for all intents and purposes, and had not been formally welcomed back into the fold. This is demonstrated by the fact that the Congress would not seat any of the representatives from those states at this point. Okay? Why would they be in a hurry to welcome the rebellious, treasonous southern states back into the Union? That's tantamount to us being roommates and you move out on me and leave me high and dry. You don't tell me anything. You know, you just bounce, and then I'm just supposed to welcome you back with open arms? No, doesn't work that way, okay? So why they feel that these southern states were entitled to some sort of fair and decent treatment after they didn't provide the Union itself with decent treatment in just upping and leaving, you know. I don't know, but they feel that because these states were not represented, it was unlawfully passed over them and they had no right to challenge it. Yeah, well, tough, okay? You shouldn't have left the Union and you wouldn't have had that problem, okay? You weren't entitled to fairness, and the Congress, okay, could deal with you however it chose. So you weren't represented. That's just too darn bad. Next, again, they felt that they were forced to ratify the amendment, okay, at gunpoint, if they wanted to be readmitted to the Union. In answering that, first of all, the 13th Amendment, which immediately precedes the 14th, was one of the 3 Civil War amendments, 13th, 14th, 15th Amendments, all right? For the sake of this history bite, we focus on the 14th. But the 13th was passed in virtually the same format. Okay? The Southern states were not represented in the Congress. Why? Because they decided to leave the Union. Oh well, nobody made you do that. All right? And next of all, with respect to them having the 14th Amendment forced upon them and being forced to ratify it, if they wanted to be readmitted, it didn't have to be this way. Okay? For all intents and purposes, the 13th, 14th, and 15th Amendments were all designed to be retributionary and punitive, especially the 13th and 14th Amendments. Okay? Congress had every right to set these amendments as conditions for readmission to the Union. My response to those scholars is the Southern states started it all. If they had never left the Union, none of this would have been necessary. However, they decided to leave the Union, thus necessitating these great reforms. Okay? Now, with respect to the 14th Amendment, again, it didn't have to be that way. When Congress passed the 14th Amendment in June of 1866, the only Southern state that had been part of the Confederacy that ratified it without pitching a fit was Tennessee. And as such, they were fully welcomed back into the Union in July of 1866, and their representatives seated in Congress. But the rest of the Southern states refused to ratify the 14th Amendment. Now, the 13th Amendment, they said, yeah, well, slavery's pretty much gone here anyway, so what the heck? All right, yeah, might as well ratify this. But when they got the 14th Amendment, they read it and were like, you serious? We have to grant the blacks equality. Negative. And all of them, not one of the Southern states that were part of the Confederacy, and, you know, other Southern states like Maryland, Delaware, that weren't part of the Confederacy, none of them accepted the 14th Amendment. All right? So, you know, and wise Southerners realized that in rejecting it, they were inviting their own destruction. And lo and behold, that's exactly what happened. With the Reconstruction Act of 1867, all right, the South was divided into military districts. All of the state governments of the Southern states that were part of the Confederacy, save Tennessee, were deposed of by the Congress. These states were required to hold conventions, okay, create new constitutions, and elect new officials to office. And only when they had ratified the proposed 14th Amendment to the Constitution, as the northern states had practically all done with only a couple of exceptions, then and only then they would be readmitted to the Union. Okay? And these legal scholars feel that no state should be forced to recognize and ratify an amendment. Well, guess what? Those states that were forced to ratify it chose willingly and knowingly to leave the Union. And Congress was merely imposing a term for readmission. Part of that was to ratify the 14th Amendment to the Constitution. And then and only then would they be readmitted. As such, once these states had complied, held conventions, wrote new constitutions, and elected new governments, they all practically ratified it. Not each and every single one of them, but all of them practically ratified it. That was required, okay? And the ones that I say not each and every single one of them, I'm referring to a couple of other southern states that were not part of the Confederacy. All of the former Confederate states, just want to clarify that, all of the former Confederate states ratified it. They had to ratify it if they wanted to be admitted back into the Union. And as such, all of them had that amendment ratified, okay, by 1870. By 1870, all of the former Confederacy was formally welcomed back into the American fold. But they assert that the way that that ratification was forced upon them was unlawful. And I'd like to know how. The last time I checked, it was unlawful to secede from the Union and commit armed treason against the United States. That's unlawful too, but they don't mention that. There was nothing unlawful about Congress imposing terms of readmission. The 13th, the 14th Amendments, certainly terms of readmission that were perfectly legal for the Congress to do. And even, you know, if that was not acceptable to them, then there's always the guarantee clause in the Constitution, which gives Congress the power to ensure that every state has a Republican form of government. And if Congress decided that those states did not have appropriate Republican forms of government, legally it could depose those state governments and force them to write new constitutions and create new governments. Okay? So, to those so-called historians and legal scholars, so-called, that feel that the 14th Amendment was invalidly proposed and ratified, perhaps you should understand, okay, the laws of war and the laws of peace. Simply put, to the victor goes the spoils, and the victor can decide the terms of peace. And the terms of peace required the Southern states to ratify that 14th Amendment if they wanted readmission. End of story, bottom line, okay? So there is nothing unlawful or invalid about the 14th Amendment to the U.S. Constitution. Thanks so much for listening to this History Bite. Any questions or controversies, leave them in the comments below. I appreciate you all for listening. Take care, stay safe out there, and I'll talk to you at the next one. Peace.